Welcome, everyone, and thank you for joining this webinar on artificial intelligence and IP in Colombia from the creator's perspective. And good morning to those of you in the Americas, and good afternoon to those of you joining from Europe. And if you're joining from Asia, well, thank you very much because it's likely the middle of the night. I'd like to say that I hope everyone is taking care of themselves, their family members, their colleagues, their coworkers. In these difficult times for all of us. Although I am happy to see that some people are starting to go back to some form of normality, if you can call it that. Here in Colombia, in beautiful Bogota, we're still under quarantine. Pretty strict one, and but slowly, more and more, some industries are starting to go back to work. So, without further ado, I'm going to start the presentation by first saying my name is Ian Racebeck. I'm partner of Racebeck and Castro in Bogota, Colombia, and I direct the intellectual property and litigation departments. And intellectual property would deal with patents, trademarks, copyrights, plant breeders' rights, entertainment law, contractual matters, dealing with IP, and obviously in litigation, litigate both civil, criminal, and administratively with regards to IP, including anti-counterfeiting work. Now, after that plug, I can go into this and so we're going to talk about artificial intelligence, AI, and intellectual property, IP, in Colombia from the creator's perspective. Now, what I mean by that is the creations created by AI systems and if they're subject of IP protection under Colombian law. So let's go ahead and start here. And the first question, why are we talking about artificial intelligence, in particular in the context of IP? Well, let me go back here. It seems that AI systems have been busy creating, and I have here a couple of examples that I'd like to show you. So first we have Obvious Art, which is a company that has an artificial intelligence system that creates paintings. The image I show here that you can see on the screen was named Edmund de Bellamy. It was an ink on canvas work interesting fact was that it was the first AI created painting that was auctioned by Christie's. And now Christie's thought that it would probably bring around $10,000 as they stated, but actually it was sold for somewhere close to $500,000, so not too shabby, I'd say. And the link you can see more of Obvious Art. They have their manifesto there. But also we have another company out of Manny, RAP, which is Robotic Action Painter. You can see the link there also. That created this particular painting, which was named 2009-06, also ink on canvas. So you can see that these are solely created by AI systems that have been trained in a particular manner. But this is not all specifically dealing with art. We also have other types of systems. We have some, in this case, OpenAI is a company that created an AI system called MuseNet, which is an AI system that creates music. And I have a small excerpt here, 19-second section of one of the works that they did that I'm going to have you listen to, just for your own curiosity, actually. You can see the link here where you can find more about MuseNet. But this AI system is interesting. It was taught, it was provided data in its teaching for different composers, different styles of music, but also different instruments. So the way it works is that you provided a prompt. In this case, the piece that I'm going to show you, or a small excerpt of it, is the group is in the style of Journey, of the band Journey, and the instruments that it's using is piano, guitar, bass, and drum. So let's listen to this. Okay, so this piece of music was entirely written by this, or composed by this AI system, which is interesting. But it doesn't only stop at music or art. But here, this last example I'm going to show you is Dabas is an AI system that was created by Dr. Stephen Thaler, or developed by him. And interesting, it created two inventions that were subject of patent applications before the EPO, the European Patent Office, and also the UK IP Office, and the USPTO, the United States Patent Office. Now, it was interesting is the applicant in the application, so the title holder was Dr. Stephen Thaler, the developer, but the named inventor was Dabas, the actual creator of the inventions. Now, just FYI, the inventions that were subject to these applications were one, a light-emitting device that was used as a signal beacon, and the other was a food container. Now, it is because of these examples and the thousands of other examples that are out there of AI systems creating that we're talking about artificial intelligence in the context of IP, as IP is precisely the area of law that deals with creations, how to protect the, you can call it the investments that were done in these creations, but in order to obtain benefits from them. So moving on, let's go back a bit and talk about what is AI. Now, don't worry, I will not go into the very technical details regarding the different neural network algorithms or systems or types and backpropagation or deep learning, which is an incredibly interesting topic, for many people, and for some of us that actually worked on AI, as I did many years ago while I was an engineer. But we're going to talk about it in the very macro sense, only to the extent needed in this particular presentation. So there are many, many different definitions of AI. I in this slide, as you'll see, I will propose one definition. But these definitions, come because of different possible expectations that the people developing the system have of the system, the type of algorithms that are used, and there are many. Or the objective in particular that the AI system has. So you can ask the question, for example, should an AI system simulate human intelligence? As if we could truly define human intelligence, difficult as it is. Or should the AI system perform a specific task or recognize a particular object or parameter? I will define AI for the purpose of this presentation, at least, as the following, as you can see on the screen: an algorithm-based system that is intended to perform a task or tasks, large or small, which solution has not been specifically programmed into the system. And that last part is very important because I'm leaving out some systems that at some point either were, or maybe some people still think that they're still some form of artificial intelligence. Which were those that seemed intelligent, but everything was pre-programmed. I don't know if some of you recall, and this will certainly show your age, in the 70s, when I was a young kid, PCs were starting to come out. And I remember there was a program, a DOS, obviously based program, that you could interact with and it seemed that you were talking to the computer. So it would ask you a question, you would respond, you could ask it a question, it would try to respond if it understood what the question was. And it seemed that you were interacting somehow with this system. But the fact of the matter is that there were just a collection of hundreds and thousands of, in programming language, if then else clauses. So if then else statements, or if you answer this, then it would do that. And if you ask this, then it would do that, and so forth. And it had multiple options. But at the end of the day, when you looked at the code, you could actually tell specifically what the output was going to be, depending on your response. Even if the system didn't understand, it would have a error catching clause, and it would re-ask the question or go back to another question. These systems, to me, are not what I would consider artificial intelligence, and so I leave them out because the programmer can specifically tell the system what to do, what the solution is. So let's move forward here. Okay, so AI systems require to be trained. Now, training will depend on the AI system itself, in the structure of it, the algorithms per se. And the results of the training depend a lot on the data used for training. So that, for example, if you could have two exact same structures and exact same randomness that's within the systems, the exact same in two different systems, but you use two different data sets for training, you're going to get slightly different results. Now, some AI systems continue learning, or better said, actually continue to be trained while they're performing their task, while others are trained up to a particular point, when the level is either acceptable or is the expected level, and then they're not trained anymore. So are AI systems trained to create? Well, the fact is, it is the algorithm itself, the structure of the AI system and the algorithm that actually defines what the output is going to be. There are AI systems which are created to recognize specific objects, figures, let's say dogs, humans, birds, or maybe a specific type of bird versus others, a specific cell. But there are also AI systems that have been developed and created to create. Now, they use different algorithms to come up with this creative output. Now, some of these AI systems create new output in the style of the teaching data set, so in the style of what was taught to the system. And the others, the algorithm requires to be sufficiently different to the data set that we use to actually train the system. And in between, you get everything in creation with respect to AI systems. So in principle, these AI systems are fed data, which is used as a teaching element. You have to teach the AI system. And then it's used by the AI system to come up with a new self-determined output. Now, you ask, is self-determined, that seems sort of human. I don't want to necessarily make a parallel between the two, but there is enough randomness, without going into the major technical details of the AI system's inner workings. But within that black box that you can call an AI system, that allows it to transform in a random way the data, so that the creation is something that the developer cannot determine a priori. So when they are creating the system or when they are training it, you cannot tell what that output necessarily exactly is going to be, precisely because of the structure of the AI system, the algorithms, and the randomness within the system. So we come to this point where we have to ask, is it the AI system then that creates? Or is it the developer of the AI system that creates? Now, we're obviously going to be answering this question, but in order to do so, I will pose this these are the two questions. Is the art teacher the author of the student's work? Or is the professor teaching technical tools the inventor of a product developed by one of the students who learned the tools from him? Let's see what we come up with now. So who or what is the creator or the author or the inventor? Is it the AI system or the development group? Well, I will pose the following. If the AI systems development group cannot determine from the beginning what the output of the AI system will be, then the creation, that is the elements of the creation, those that are creative, original, self-determined, however you want to call them, are those of the AI system and certainly not of those of the developer. Because the developer, like I said, cannot determine what the output actually will be. And in that sense, it is the AI system which would be the creator. And that is extremely important. I will try to exemplify this even more by going back to the question and answer them. Think of a student studying under a famous artist, a famous painter, learning his or her techniques. And should the famous artist be considered the author of the works performed by the student? I don't think so. Actually, people would say no. Obviously, despite any of the similarities in techniques and or themes or topics acquired from the master, I mean, that's what students do when learning from someone. But certainly, the master would not be considered the author. And it's the same for inventions. If you think of a PhD student doing his dissertation, and he's acquiring knowledge, experience, learning how to use certain tools from his professors. Well, that doesn't mean that I would say that his professors should be named inventors or should be considered the inventors of the creations that are performed during the dissertation, or even years after he left school and had graduated with his PhD. I don't think, and I'm pretty sure most of you would say that it is not the professor who is the inventor because he taught those tools to the student. So as a consequence, in principle, we cannot consider the developers of an AI system who developed and trained the system as the authors or inventions of the AI system's works or inventions. They are the AI systems, works, and inventions, and they should be, and it is those systems that should be considered the authors or inventors. So we come to this point, and this is the nut of this presentation here, what we're discussing. Can an AI system be an inventor or an author? Because they are, but subject of IP protection with respect to their creations? That is the question, citing Shakespeare. So the quick answer, but I will explain it though, is, as you see on the screen, inventors and authors in Colombia can only be natural persons. Now let's go through it and explain why. For patents, we have Andean Decision 46, and it covers this. Andean Decision covers all Andean countries, which are Colombia, Ecuador, Peru, and Bolivia. And Article 14 of Decision 46 reads as follows. Member countries shall grant patents for inventions, whether they be products or procedures in all areas of technology, provided that they are new, involve inventive step, and subject of industrial application. So patents are granted for inventions, and they say nothing as to the nature of who created it. So in principle, you think that if a creation was created by an AI system, an invention, that if it met the patentability requirements, which, as you see in Article 14, are novelty, inventive step, and industrial application, as it is in most countries, then you think that it should be patented. But unfortunately, that's not all. Then we go to Article 22 of Decision 46, and it says the following. The right to a patent shall belong to the inventor. That right may be transferred inter vivos or by succession. Then it follows and says the owner of a patent may be a natural person, may be natural persons or legal entities. Then it goes in further. But this is the important aspects. So by taking this all in, I believe that Article 22nd leaves little of, if no room, but to conclude that the inventor must be a natural person. And why? If we go back, remember this last review says the right may be transferred inter vivos or by succession. So if the right of the patent belongs to the inventor, which it does, and such a right can only be transferred or assigned while the inventor is in existence, which is why it says inter vivos, so between live people, or through succession, which requires death, then we can only conclude that the inventor must be a natural person. In addition to that, on that second part of Article 22nd, if the title holder of a patent can be either a natural person or legal entity, then a natural reading of this entire article would suggest that the inventor must be a natural person who may assign his right to another natural person or to a legal entity. But the inventor itself must be a natural person. Now, if you're unhappy with that, the Andean Community Justice Tribunal, which is the only entity that can interpret or allowed by law to interpret the decision 46 or any Andean decision, has indicated in its guide for patent examination that the examiner must verify that the inventor is a natural person. So, we ended the discussion there. If they're the only ones that can interpret the law, and they've stated that the examiner during patent examination must verify that the inventor is a natural person, it is saying that inventors can only be natural persons. So let's move on to copyrights, which is even clearer here. Decision 351, again, is an Andean decision which applies directly in these countries, including Colombia. Article 3, which is the definitions article, says for the purpose of this decision, then it talks about the author and the work. Author is a physical person that performs the intellectual creation. At least in part it says that. And work is any original intellectual creation of artistic, scientific, or literary nature susceptible of being disclosed or reproduced by any means. Now, going back to the author, it can't get any clearer than that. It's a physical person that performs the creation. So, similar to patents, even though the definition of work or invention refers only to the creation itself, to the creation aspect, and in no way is limited by who the author may be, who or what, certainly the author of the work is clearly defined as a natural person. In addition to this, in several case law issued by the Andean Community Justice Tribunal, for example, prejudicial interpretation 139 IP 2003, it is stated clearly that the author of a work must be a natural person. So there's truly no discussion there. So more important than that, which in itself is important, is what are the implications for patents and copyrights if the inventor cannot be, or the author cannot be, an AI system? Well, the implication for both patents and copyrights is very similar. So regardless of the merits, artistic, social, economic, technical, of the work or invention, there would be no legal protection via copyrights or patents for work or invention created by an AI system, simply because the inventor cannot be an AI system. It has to be a living human. And what that means in consequence then is that the benefits provided by the legal protection provided by patents and or copyrights could not be redeemed. And this raises a huge question on whether investment in AI systems for the purpose to create, because there are other applications of AI systems which you all know, recognition of many aspects or classification. But it raises the question of, is that investment warranted? Because if there's no copyright protection on, for example, the pieces of art that I showed you earlier, if there is no patent protection for the creations created by Davis, by the inventions created by Davis, then you can't reap the fruits of your investment in that, which is the purpose of the patent system, and in many ways the same as in the copyright system. So those are major implications. And then I come to the question of, are there any solutions within our law to allow AI developed inventions and works to seek protection? Well, I cited the law here, both in patents and copyrights, and the current wording of it is quite clear, and I think it makes it quite difficult for the Anti-Community Justice Tribunal, which I remind you is the only entity that can interpret the law, to make sensible interpretations, to allow the someone or something different from a natural person, without stepping outside the boundaries of the current redaction of the law itself. So, one solution would likely entail just modifying Decision 486 and 351 to expand the definition of inventor and author, respectively, either to include non-human inventors or authors, or to redact it in a way that it really doesn't matter who or what is doing the creation. Another possible solution, which sort of contradicts the first bullet point here, but it would be to consider that the developers of the AI systems be the inventors or authors. But to me is one of those unclean solutions. But because we have already discussed and we know that it is not the developers who are doing the creative part, the creation. They created the AI system that is doing the creation, but they're not the ones. So naming them as inventors or authors is really not a clean solution, but it can eventually be interpreted that way and be a potential solution here. At this point, I'd like to remind you that you can ask questions. I'm not able to see them right now, but as soon as I end the presentation, I will see them, and I will spend some time answering if you have any questions. Through the chat. If you have a YouTube account, you can do it directly. If you have a Gmail account of any sort, you automatically have a YouTube account, so you can actually ask questions also. And I said this then because now we're concluding. So what we conclude here? So inventions and works created by a system which would in principle be able to be protected because of the merits of the invention or the work meet, and also they meet the legal criteria in case of patents, novelty, inventive step, and industrial application. And in case of copyrights, originality, they are not subject of IP protection under current Andean laws. They're not. I believe that this dissuades investments in the use of AI systems for the purpose specifically of creating, as you cannot reap the fruits of your investment via patents and copyrights. However, lastly, it's well known that law is or should be a reflection of society. And because we're heading into this, we're actually not heading. We are already in an AI system, where AI plays an incredible role, and it will increase. The role will not diminish; it will certainly increase. I believe that we merit a very serious discussion over the inclusion of non-human inventors as authors or inventors of their creations. In order precisely to keep up where our society is going and where our interests and the investments are going to. And as a personal note, in this last point, I said that it merits this deep discussion and reflection. I personally am in favor of having AI systems be considered inventors or authors, despite the fact that as a society we may be able to decide that we don't want them. So with that in mind, I'd like to thank you very, very much for paying attention to my presentation here. I hope you enjoyed it. And I will now going to change this webcam mode only. Here I am. There we go. And this will allow me actually to look at the chat here and see if there are any questions, which I don't see in it, but here, let me check this out. Any questions? There we go. So I'll wait a few minutes in case someone has any questions, but if not, I would think that maybe the presentation was incredibly clear for everyone. Let's see. Here someone is asking this, Nasen, what do you think about the possibility of the electronic person, like a way of regulation? I'm not sure I understand the question. Let me read that again. What do you think about the possibility of the electronic person, like a way of regulation? Okay. Yes. I think these are all legal fictions in the sense of saying, well, because a person is considered to be a natural person, can we now expand it to be an electronic person, but still a person? It would be one of those fictions to make sure that all creations that are non-human creations can also eventually be protected. But it actually goes more than that. Let's leap into 10, 20 years. I don't think much more than that. And where we have actual AI systems have personality, actually, that we have developed them enough intelligent that maybe they'll be able to have some similarities to animals or maybe to human beings in that short of a time, in terms of how the human brain works and the intelligence that we can assimilate to that. And if that is the question, then the question is, should they have rights? I remember a couple of movies that talk about that, actually. But it's a reality. Should we allow some intelligence to have, sort of electronic or man-made intelligence to have certain rights, whatever they may be, including patents, IP rights? But I will actually say this. Imagine that there were extraterrestrials, and imagine that those extraterrestrials came to Earth, and imagine that some look just like humans. Would we allow them to participate? But if they don't look much like humans, should we not? It's a very interesting question. I think I don't think we'll answer it here, but let me move on here. We have a second question. At what point do you suspect that the current IP laws will be changed? Well, I'll tell you, this is my son, Ian Raisbeck, also asking this question. Hello. I can't tell you that the laws will be changed. Maybe as a society we'll decide that we don't want inventions created by AI systems or works of art or any other type of creation protected. I hope that they are, because the only reason I think that we would not would be sort of, we feel that those systems could be more intelligent than us and now we're inferior. And I always think that as a human race, we give our best when we have competition. And if we have intelligent systems competing with us, I think it would just make us more intelligent, use their brain more. Not sure. I have one more question. Oh, yeah. No. That was the same as before. It was just explaining. Yes, I think I understood it, what it was as a legal personality to the machines. I think I've answered those. Any other questions? Let me wait a minute or so more. In the meantime, I'd like to thank everyone again for joining. It's been a pleasure, in particular this topic, which I love, AI, and I, I thank very much the opportunity that I had when I was doing my master's thesis to be working on AI, trying to diagnose multiple sclerosis at that time, but it can be used in many ways. Someone is asking something in Spanish. Okay, we actually have the Spanish version of this webinar today at 2 o'clock Colombia time, 3 o'clock US Eastern time, but let me translate it. She's asking if, with respect to the similarities between the figure of the author and inventor, is it not more probable, based on the logic behind each regulation, that it would be permitted to patent as opposed to copyright? Maybe. Part of copyright is it's thought of as a cultural and a social representation, and it's important to maintain it, and that's why copyright laws protect for much longer than patents. That's generally the answer there. And so if the machine is the one creating, is that considered part of the culture or the society? I'm sure a lot of people would agree with you, or would say that it's more likely that this would take place in patents and in copyrights because of that. However, I've always been an advocate for the fact that developing technology, and so inventing, and in that sense patenting, is a way of life. It is a culture. There is a culture of inventing, and there is sometimes in some cultures lack of. So disregarding or just thinking that patents is purely a financial aspect, and it has no reflection in society on where we're going, I think it's a lie, but that's just my personal opinion. But I think you may be in practice right, where it's likely this to move forward more in the direction of patents than in copyrights. But I think the discussion is merited for all IP rights, including plant breeders' rights, and eventually other rights. Okay. Well, I don't see any more questions. So being almost 10 minutes past the end of this presentation, I'd like to again thank everyone for joining. And if you have any questions here for a second, I will leave for about an additional minute. My email address or website, so it's ian.raisbeck, RAISBECK @roclaw.co. You can write to me if you have any further questions, and I'd be happy to respond to them. Well, I was going to leave, but there is an additional question. Okay, she's asking in Spanish, but I'll translate it. Today, there are other options to protect AI products, such as trade secrets. Do we need other regulations? Well, actually, I think there's a little bit of lack of understanding there between on what trade secrets protect, and the difference between trade secrets and patents. And Okay, let me put it back on webcam only. And the protection that you can have using both, actually. Um, so um, trade secrets maybe is a useful tool, certainly, but it's not for everything. I mean, protecting certain products with trade secrets is extremely different because they're out in the market. Certain procedures, yes, but if they're easily discoverable, or you won't have a trade secret. And the fact of the matter is that you never know if you have a trade secret until you litigate it, because you don't register a trade secret. You just comply with the regulations to attempt to meet the requirements of the trade secret, but you never know if you have it until you litigate it, where you have to declare first that it is a trade secret. Whereas with patents, when you obtain a patent, you know that you have the patent right, so it is much clearer. So they're independent rights, and I don't think they protect the same thing. But many companies actually use them in conjunction with, not interchangeably at all. And in many cases, and that is why there's so many patents out there. You want to protect your technology with a patent. And in many cases, it would provide you a longer protection than if you didn't have patent protection and you put your product out there in the market. Now, obviously, there are exceptions to this. So with that in mind, and it being 10:41, I'm going to close this off. But thank you very, very much for your time and attendance. And like I said, if you have any questions, I will leave here the last page, which includes my email address, and you can write to me with any questions. I'll be happy to respond. Thank you very, very much, and we'll end with this.